Hi guys, it's Kathy. I hope you're doing well. Wednesday. Today is Wednesday. Yes, sir. All right, we go to courtroom Q today. Hmm? That's what I got. I got cutie pie. Yes, I did. I don't know what happens. I know, like 2.5 hours in, there's a very sensitive case, but that's the only one I know because I fell asleep. So, hopefully, nothing bad. He does take some bad cases sometimes, but not today, sir. Not today. Be nice. Maybe he'll smile today. That's all we're waiting for. We're just waiting for a genuine smile, not one of those friendly grimace smiles. They don't count. Good morning, guys. No, I don't. It's nothing we can switch on and off from our end, Callie. It's YouTube. Tomorrow morning is D stream. Tomorrow morning is Judge Crawford's divorce. Oh, well, not his divorce. I can't even imagine him getting a divorce. He goes home and he sits. Why would you divorce that? Smile, Judge. Smile.
Morning, Mr. Edie Tolliver. This is 25 CR 1804. I'll take entries starting with the people.
Honor Lansbaum for the people.
Tempest Cantrell, Mr. Edie Tolliver's behalf. He's out of custody to my left.
Thank you. This matter comes on for arraignment. Ms. Cantrell, how would you like to proceed?
Yes, Judge, I'm asking to continue the arraignment. I sent some evidence to Ms. Lansbaum and she wants to re-interview the victim before making a decision about how to move forward. So I'm asking to continue the matter. He is set in Division 5 on October 24th. Looks like this court is not in session on the 24th. So I just asked for a set over after the 24th so that she can interview the victim.
Thank you. Ms. Lansbaum?
Your Honor, that's correct. There are some things that we very much need to follow up on based on what was provided by Ms. Cantrell in the middle of last week. We have not been able to follow up at this point.
Okay, thank you. I do find good cause to continue the matter for further arraignment. It'll be the third arraignment, so likely a final arraignment. We'll find a date after the 24th. Ms. Controller, Ms. Lansbaum, will either be able to accept an off day? Our Tuesdays are pretty heavy set through December.
I think it depends on what day it is.
Fair enough. Okay, yeah, we'll look at a Monday or a Thursday.
How's November 6th at 8:30?
I can accept that.
I can accept that.
Okay. Well, I'm sorry, folks. I prefer not to set that week right now with our trial schedule as well.
The Loya Martinez trial.
Well, I'm looking at Gomez Roman trial, but
How's the 13th, November?
He has court in Denver on that date.
I wonder if we should do something, guys. I wonder if we would get bored or if we should do something. They're talking about November. He has 2 trials. I don't know what they are. I don't know if they're good, bad, or indifferent. What if we followed this judge for November? I mean, we don't have to. But he has 2 trials coming in November. What if we just watched his dockets? We would get bored. I'm already bored. Never mind.
Can you do November 12th?
I can.
I can accept that.
okay. Thank you. Matter will be set Wednesday, November 12th at 8:30. Anything else from either party at this time?
No, Your Honor.
No, thank you.
Okay. All right. Thank you, Mr. Tolliver. We'll see you back then, sir.
Yes, sir.
Yes, sir.
Judge, I'm ready to call Mr. Wheelock's case.
Thank you. Morning, Mr. Wheelock. I'm doing well, thanks. This is 25 CR 349. I'll take entries starting with the people.
Your Honor, actually, Ms. Elwell wants to be present for this case being called. I didn't know we were ready to call it.
Okay.
Just have a moment to get her.
All right. Sorry, Mr. Wheelock, give us just a few minutes till the DA is here, okay?
Second, you can just have a seat.
Is Melvin De Leon present?
That didn't work. I can't fix this thing right here. It's driving me crazy. And my mic's not on, but you guys see what I'm seeing? See how my hand disappears? I've been trying to subtly fix it for weeks. Look, it's not working. CJ, don't work. Judge, we don't have time for you to sit around like this. Where are we? We're at 1 hour and 1 minute. Let's go to 1 hour and 3 minutes.
Okay. Thank you, Mr. Schneider.
We missed the whole thing.
And then we could call Mr. Mir as well, Your Honor.
I don't
Okay.
care.
All right. We'll call 25 CR 10001, People versus Derek Muir. Morning, sir. I'll
Yeah,
take
that's what I
entries.
thought. I thought it might be the camera, but
I'll take
it's
entries starting with the people.
not the camera.
Lands the people, Your Honor.
Aaron
Let me
Brockman on
just-
behalf of Mr. Mir. And Your Honor, I just realized at the last court date, we had mentioned pulling in a misdemeanor plea as well. There is paperwork filed in that. That case is 25 M2687.
Okay. Ms. Lansbaum, any objection to adding that on to proceed with the plea?
No, Your Honor, I was the one who provided the paperwork.
Okay, thank you. All right, give me one moment.
Yeah, 1 moment. We haven't done anything
So
yet,
the court's
Judge.
aware 2687.
Good news, guys. Good news. Tomorrow, I think I might get a discount on my coffee. Because today, it has taken an hour and a half so far for 2 cups of coffee. An hour and a half. They might give me a little coupon.
Is a DUI with a BAC of a .212. It's a DUI second outside of 5.
Outside 5, you said?
Yes, Your Honor.
Okay, thank you. Okay, Mr. Mayor, I'm going to go through this paperwork in both cases with you.
It's
At any
the
point you have any
background.
questions, feel
It's 100% the background. And it's 100% an OBS issue. Because, so if I move just the background in, I'm just going to move the background in. See how, oh, you can't see. the background stops way over here, but it's pushing in. Yeah, words are not working today. It's the background. I just don't know what it is. I just don't know how to fix it. This little strip right here.
Feel free to stop me. You can ask me or Mr. Brockett, okay?
Yes, sir.
Sorry, one more. Okay, and I'm sorry, Ms. Lansbaum, are we very compliant as to the plea?
Yes, Your Honor.
Okay, and are we asking to move forward with the immediate sentencing?
Yes.
Okay. All right, so Mr. Mayor, I'm going to go through the paperwork in both cases. If you have questions, feel free to stop me. You can ask Mr. Brockett or myself. Looking at 25 CR 1001 and 25 M 2687. And both of those I have proposed dispositions or Rule 11 advisements. Did you have time to go through the plea paperwork with Mr. Brockett?
I did, Your Honor.
Do you need more time with him to talk about the paperwork in either case or what you're doing today in general?
No, Your Honor.
Okay. And in the 25 CR case, there's a signature here on the defendant line. Is that your signature?
Yes, it is.
Wawa DoorDash.
And there are also initials at each of the paragraphs in the 25 CR paperwork. Does that mean you went through each paragraph with Mr. Brockett and understood them?
Absolutely, Your Honor.
Thank you.
Absolutely, Your Honor.
According to this, in 25 CR 1001, you're pleading guilty to 2 charges. Count 3, a Class 1 misdemeanor prohibited use of a weapon, and Count 4, a Class 1 misdemeanor menacing. Is that your understanding?
Yes, Your Honor.
And in 25M 2687, looks like you are pleading guilty to, as Ms. Lansbaum stated, a DUI with 1 prior that occurred more than 5 years ago. Is that your understanding?
Yes, Your Honor.
Did you read and understand the elements for all of those charges?
I absolutely did.
Did you read and
Absolutely,
understand the
Your
possible
Honor.
penalties for those
Absolutely.
charges?
I absolutely did.
Do you understand that in both cases, you do have the right to a jury trial as to the original charges?
Yes, Your Honor.
And do you understand that by pleading guilty today, you're waiving that right to a trial as well as all the rights listed in paragraph 9 on the 25 CR matter and in section A on the misdemeanor matter?
Yes, Your Honor.
Okay.
Excuse me.
And Ms. Lansbaum, is there any restitution requested in the 25M?
No, Your Honor, there's no restitution. And there's no restitution on the 25 CR either.
Okay, thank you.
Closer.
It's my understanding in the 25 CR case that people are recommending that you complete an alcohol evaluation and treatment and probation that will run concurrent to the misdemeanor matter. Is that your understanding?
Yes, Your Honor.
Okay.
I absolutely understand.
Great. And it looks like they're also moving to forfeit the firearm that was used in the 25 CR offense. Is that your understanding?
Yes, Your Honor.
And finally, look at the 25M case. There is a mandatory minimum as to that charge. People are recommending 10 days of in-home detention with 2 years
Fine.
of probation, as well as the alcohol evaluation and treatment. Is that your understanding?
Yes, Your Honor.
Okay. Do you understand that ultimately the sentences in both these cases will be up to me?
Yes.
Has anyone made any promises to you about what the sentence will be other than what's listed in this paperwork and what we just talked about?
No, Your Honor.
Thank you. Is anyone forcing you or putting pressure on you to enter into these pleas?
No, Your Honor.
Are you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening this morning?
Absolutely not, Your Honor.
Great. Any other questions for me or Mr. Brockett at this
True.
point?
No, Your Honor.
Thank you.
True.
Then in 25 CR 1001, as to count 3 and 4, both class 1 misdemeanors, how do you wish to plead guilty or not guilty?
I plead guilty, Your Honor.
Thank you. I'll accept the plea in that matter. And in 25M 2687, as to the misdemeanor DUI offense, how do you wish to plead guilty or not guilty?
I plead guilty, Your Honor.
Thanks, sir. I think you'll find that both pleas are knowing, intelligent, and voluntarily made. We proceed forward with sentencing. Mr. Brockett, I'll turn it over to you, sir.
Thank you, Your Honor. I'll start just by saying that Mr. Muir has a very limited criminal history outside of these cases. I think it mostly consists of that DUI, which is quite old and out of California.
Oh, my mic is on
I do
still.
think these cases were a wake-up
Why?
call for Mr. Muir. He was suffering from some alcoholism, and I'm so impressed with everything that he's done. I think he is a shining example of how to turn things around.
Thank you for the cheers,
He got
Kelly.
to work
Thank
pretty
you.
much right away. He realized he needed to change his circumstances, and he initially completed a 30-day program through Colorado Addiction Recovery Services. He is now in a 90-day PHP program, also through Colorado Addiction Recovery Services, and is set to finish that on November 29th. And then he's already setting up sober living through True Recovery, plans to be there for at least a year after that. He's also started working with 2 different peer recovery coaches, one through Heart Beauty and one through NAS. He is also working with a therapist through Trend for mental health. He also has a clinician and a case manager through CARS, and he is also working through with Cross Purpose through their launch program for career building. So he is putting in a tremendous amount of work. He's remaining sober, and he's extremely focused on getting his life back on track and just moving forward. And he has done this all on his own. He's gone out and sought these resources and really turned things around. I have no doubt that he is going to stay on that path and never find himself in this position again. He did on the 25M2687 matter, he did spend 16 days in jail. So I just asked that to count for I believe the paperwork says they're asking for 10 days in home detention, but given that he's in a program and has that credit, I would ask the
Thank you
court
for the
to,
cheers, Kelly.
to use that instead. And then also I would ask the court on both of these cases to suspend any fines and costs that the court is able, as while going through these significant programs. He's currently not working, and recovery is his main focus.
Thank you, Mr. Brockett. Ms. Lansbaum?
Your Honor, I'll start with a VRA record for the 25 CR case. The victim, as well as the mother of the child victim in this case, are fine with this plea offer. What both of them stated to me in 2 very separate conversations is that they care most about the protection order. They do not want Mr. Muir back around them. And I can understand why, based on the allegations here. This is one of the thickest mitigation packets I've ever received. And that is the reason why this offer is being made. And I am hopeful that this is the wake-up call that Mr. Muir needed, and we do not see him in front of this court ever again. I'm optimistic. As far as the DUI goes, it was a DUI with a .212. However, thankfully, there was no crash, there was no accident. It was a pretty simple pullover. So I'm asking that the court impose a probation sentence with alcohol treatment as required by probation for DUI, and run those concurrent. I am
Thanks
also
for the
asking for the
cheers,
mad victim
Monica.
panel.
Thank you, Ms. Lansbaum. Mr. Muir, anything you'd like to let me know, sir?
No, Your Honor.
Okay. Sounds like Mr. Brockett and Ms. Lansbaum covered quite a bit. Seems like you've been putting in a lot of work, Mr. Muir, and I'm glad to hear that. Obviously, want to keep you on that trajectory. So I agree with Mr. Brockett as to the minimum. I think credit for time served is appropriate. So looking at 25M2687, I will sentence Mr. Muir to a period of 2 years probation. I will impose 16 days in the Adams County Jail and grant 16 days of pre-sentence confinement credit. As to the mandatory minimum there, I will order Mr. Muir to complete an alcohol evaluation and corresponding treatment. Order that Mr. Muir not consume alcohol or any other controlled substances except by prescription. I'll impose 48 hours of useful public service and complete a MAD victim impact panel and suspend a $600 fine on successful completion of probation. In 25 CR 1001, I'll impose 2 years of probation to run concurrent to the other case. Alcohol evaluation treatment will be a condition of probation there, as well as compliance with the restraining order. No restitution is requested in either case, so both sentences and judgments will be final today. Mr. Brock, anything further?
Sorry, just 1 second.
Sure. No, just, yeah, 16 days.
Your Honor, if we could have transfer of probation to Denver authorized, please.
Thank you. Ms. Lansbaum, any position there?
I take no position.
Thank you. I will authorize transfer of probation to Denver. I'm sure Mr. Brockett's already explained this, but you still need to start in Adams before you move to Denver, so make sure to start here, okay?
Okay.
Thank you. Ms. Lansbaum, anything further?
No, thank you.
Okay, so Mr. Muir will have some paperwork for you in just a minute to sign the terms and conditions of probation. After that, check in with probation on the 3rd floor to get your supervision started, okay?
Absolutely, Your Honor. Thank you.
Thanks, sir. Good luck to you. Keep up the good work.
Thank you so much.
Morning, Ms. Cantrell.
Good morning. We're ready to recall Mr. Wheelock's case.
Thank you. All right, this is 25 CR 349, People versus Wheelock. I'll take entries, starting with the people.
Good morning, Your Honor. Shannon Elwell appearing for the people. I would note for the court the presence of the victim representative, Janelle Goodrich, on WebEx.
Thank you. Good morning, folks.
Tempest Cantrell on Mr. Wheelock's behalf, covering for Kimberly Gonzalez. He's out of custody to my left.
Thank you. Good morning. This matter comes on for arraignments. Ms. Cantrell, how would you like to proceed?
Yes, Judge, I'm asking to continue the arraignment. Ms. Gonzalez has been in touch with the assigned district attorney. They're trying to set up a meeting sometime in November. So I'm asking that the court set this over until December on a Tuesday or Thursday.
Thank you. Ms. Elwell?
Your Honor, I am the new assigned.
Listen, if you're going to try to understand the Crown, then you're in for failure and disappointment. You can't understand the Crown.
District attorney, so she may have been reaching out to Ms. Sisk, but just so Ms. Cantrell knows, Ms. Gonzalez can reach out to me. I'm not objecting. This is a first arraignment, Your Honor, and like I said, I am the newly assigned attorney. Unfortunately, I am slated to be in a 2-week murder trial at the beginning of December, and then I'm out of the country. So if we could set a little further into January, I just think realistically, December's not going to, Ms. Gonzalez and I are also trying a 2-week murder in November. So I don't think December is going to be very fruitful.
Okay. Ms. Cantrell, any objection?
I just don't know any other profession that goes out of the country as much as lawyers. They are always out of the freaking country. They're not just on vacation. It's not like I'm on vacation that day. That's fine. No. I'm in France. I'm in Italy. I'm in Spain. I'm in Ireland. I'm in London. They're out of the country.
Until looking into January.
No objection.
Okay. Thank you. I do find good cause to continue the matter for arraignment. We'll find a date in January. While Ms. Taylor is looking at that, I'll let folks know I did receive a motion request from the people to review
Kelly,
DHS
thank you.
records in
Cheers.
camera.
Thank you,
They're
thank you.
in the court file and under seal. Fortunately, those didn't get to my inbox, so I'm going to review those. Now that I'm seeing them, I'll release them by the end of the week, any that are discoverable.
Thank you.
How's Monday, January 6th at 8:30?
Could I have a Tuesday or Thursday?
That's Tuesday.
That's fine for me. Thank you.
What was the day again? Sorry,
That's good.
Tuesday,
I think it
January
was
6th.
Tuesday, January 6th. Okay.
it should work.
Okay. Thank you. Bond
good.
will continue. I'm sorry, you said that worked for you, Ms. Cantrell. Is that right?
Sorry, Miss Gonzalez just messaged me that she's in bond advisals that entire week.
Okay. We'll find a different date or a different week, I suppose.
Tuesday, January 13th.
That's fine for the people.
That works.
Okay. Thank you. Bond will continue then to Tuesday, January 13th at 8:30 for arraignments. Ms. Cantrell, anything further this morning?
No, Your Honor.
Thank you. Ms. Elwell, anything further?
No, thank you, Judge.
Okay. All right. Thank you, folks.
Thank you.
No, not you, thank you. Missing a defense.
Was Mr. Bivick? Okay.
I don't know why. I have no idea. Maybe create a whole brand new account called what you want it to be called, and then trash this account.
You're ready. Yeah, well, Marina didn't answer her phone from the interpreter. Also didn't answer.
Guys, he
so-
keeps moving.
I know, but I didn't know if she was with
needs to
Marina
stay
because I can see Marina
still.
on there. So I was just trying to make sure that if she needed it, but
I heard from.
I don't want to make him smaller.
we emailed their attorney.
If only
um,
Reyes and her would switch sides, then I can make
let
them
him know
both
that
bigger.
Okay. Ready to call it if you're ready.
Okay. Looks like we're ready on the Gomez Roman matter. This is 22 CR 3474. I'll take entries starting with the people.
Jesse Forrest for the people.
Good morning, Your Honor. Frederick Bibick and Maureen O'Brien appearing with and on behalf of Mr. Gomez-Roman.
Thank you. Good morning, everyone.
We also
Yeah.
have the county attorney is present as well for the SDT.
Morning, Ms. Hinojosa.
Laura, excuse me, Laura Hinojosa, registration 40087, appearing on behalf of the Adams County Sheriff's Office.
Thank you. Good morning. This matter comes on for status and hearing concerning a number of pending issues. It looks like it makes sense to start with the SDT from the people. And Ms. Hinojosa, do you have responsive records as to that?
I do, Your Honor. I did want to make a little bit of a record.
Please.
In looking at the subpoena ducis tecum as well as the notice and the rationale for issuing this, the subpoena itself mentioned the IA records, but then the notice talked about the ruling in the Goodson case. If the court recalls, there was an IA and HR records. And so in order to comply with the spirit of the subpoena ducis tecum and the court's ruling in the Goodson case, we did provide both of those on this subpoena ducis tecum. If I would join in the people's request for an in-camera reviewer, Martinelli, and I would also ask that anything that is released is subject to a similar protective order.
Okay. Thank you, Ms. Yes, you may. Thank you.
He's not cute.
Okay. Thank
He's
you.
a
I've been
cutie
provided from the
pie.
Adams County, the looks like one thumb drive. Ms. Forrest, any further record as to the people's subpoena?
Cutie pie.
No, I would just ask before we release the county attorney that we set, because my request is going to be to set a date so we can address the defense's motion regarding Rule 16 once the court releases the records. And if we could do that while the city attorney's here,
Hi,
or the county
Smith.
attorney, excuse me, just so we can clear the date.
Okay. Thank you. And Mr. Bibick, any record as to the subpoena issued at this time?
Yes, Judge. I believe the issue as to the records pertaining to Karen Carroll is previously litigated in the Goodson case. I don't see a difference between this case and that case in terms of the issues these items disclosed with respect to impeachment of the credibility of Ms. Carroll. It seems to me that the issue is res judicata, and I'm asking for release of those records now. Any delay further prejudices us. We are in the last stages of preparing for trial.
Do you know what county
This
you'll be
issue,
in?
which should have come to us many months ago, is only coming up now. And it's taking away from our increasingly precious time between now and the start of trial to address this issue. So I want those now. We've also learned through the Goodson case that there's other records pertaining to the crime scene investigator, apparently a trainee at the time, Dallas Janicek. Her name has recently come up since we only recently got the chain of custody records on this case. And we're requesting similar
I
records
can
as
get
to her
Mesa County
HR
easy.
records and any records pertaining to
The
her
week of Thanksgiving.
internal affairs investigation.
Okay. Thank you, Mr. Bibick. And
Maybe
was
we'll
Ms.
see you get
Janacek a
arrested.
endorsed witness or anticipated witness in this case?
No,
Do
she's
it,
never been an
Sherry,
endorsed
get
witness.
arrested.
We don't anticipate calling her. Her name only appears once in all of the records, and that was just on the chain of custody form that we received recently from the police department. So we,
I'm so happy. My coffee is here, guys. Guys, my coffee is here. I've never been so happy in my entire life, I think.
are now calling her as a witness and never endorsed her.
We may want to call her as a witness as to her involvement with Ms. Carroll.
Okay.
And Judge, my only kind of response to that is, since the people are not calling her as a witness, the defense, I guess, is asserting that they would like to have this witness testify and then go into specific instances of conduct, which would not be permissible on direct examination. So we, again, are objecting to any type of court order for the release of Dallas's records, who again is not a witness in this case.
Okay. And it's okay if you don't have this information, but what aspect of what piece of evidence was Ms. Janacek on the chain of custody?
I can look at that. I didn't even notice that she was on there until defense counsel mentioned it.
I think Ms. O'Brien may have that information at her fingertips.
Okay. I think I've unmuted there. Good morning, Ms. O'Brien.
Good morning, Your Honor. Am I unmuted now?
Yes.
Okay. Your Honor, Miss Dallas Janacek appears throughout the chain of custody on almost every item that was collected. She was the one that was logging them all into evidence, and we didn't know about her until we just got this recent chain of custody report, but she had her hands on almost every piece of evidence. So we've got the person who collected the evidence, which is Karen Carroll, and she collected almost every piece of evidence in this case. And then Miss Janacek logged in almost every piece of evidence. So when I saw her name appear in the Goodson case, when I had to buy that to see what exactly the prosecutor was talking about, because they only gave us a case number, so I bought the case, read through the motions, and saw that there was also a problem with Miss Janacek, whose name I recognized from just getting the chain of custody. So I think she's a very important witness now because she touched every piece of evidence. And part of the allegations, from what I understand from Miss Carroll and possibly Miss Janacek, is tampering with evidence.
Okay. Thank you. Thank you first as to the records that the court has received regarding Ms. Carroll. Obviously, I am privy to the contents of some of these records given prior proceedings in the People v. Goodson matter that's been cited by the defense. I do find that there's a good faith basis for the request of the records from the sheriff's office, given the court's prior orders and some of the findings there. I don't find that this is a fishing expedition, and these records cannot be obtained through other reasonable means, given the court's protective order and the confidential nature of the records. I still find that an in-camera review is the appropriate course of action here. There are some meaningful distinctions between this matter and the Goodson matter in terms of some of the allegations that the court has knowledge of. Furthermore, any records released, and parties should expect at least some records to be released, will be subject to a protective order as requested by the sheriff's office. As to the request for further orders for Ms. Janacek, again, through the Goodson matter, the court has some awareness of the nature of the IA investigation and a finding there that would potentially invoke the 16.2.5.502 of some findings that would require mandatory disclosure. It sounds like Ms. Janacek was not necessarily an endorsed witness, but now is present on chain of custody logs. So I do find good cause to order the department, with my apologies to Ms. Hinojos. She's been here several times in the last several weeks, to provide any records related to Ms. Janacek's IA investigation, as well as any relevant HR records related to the investigation and the related IA investigation. Ms. Hinojos, is that sufficient direction for you and any other record on that?
Grandparents' Day,
The
yes.
court's ruling, I don't know if there is any companion HR case or anything, but we will, the sheriff's office will look into those records. And then when is the court ordering their disclosure by?
When is realistic, Ms. Hinojos? Good, just given, I think we're 2 weeks out from trial.
Your Honor, there's a representative from the sheriff's office here who has indicated she would be able to deliver them to the court tomorrow.
Okay, I'll order those be provided by tomorrow at noon. Is that realistic?
And that's
Okay, and then we'll notify the parties. I'll review those quickly, and we'll have those available tomorrow. The Carroll records I will have available for the parties today. I
That
do
is
still have
terrific.
a few cases left on the docket and a preliminary hearing this afternoon, but we'll make sure those are available for the parties today. Parties want to make sure they get them today. Plan on a pickup late afternoon.
Very well.
Okay.
Judge, we've also, in my request here, we've requested release of the exhibits that were attached to the Goodson motion. That's going to speed things up for us, I believe, and so I think I made an adequate record within the motion.
Okay. As to that, and frankly, I think the records attached to that motion should have been listed with a different security protocol. Those were all subject to the court's protective order. So at this time, I'm not going to order a release of those records, but I can let folks know that most, if not all, those will probably be responsive documents that you'll be receiving today. I don't think any of those were obtained outside of the IA files or HR files subject to the court's protective order.
Thank you.
Thank you. Ms. Forrest, anything on that?
Since there's still a
Oh.
pending defense motion regarding possible Rule 16 violation, we need to set a date for that. And I think the county attorney wants to be present for it. So I'd ask if we could set that date right now before we
Okay.
release.
Yeah, we'll do that. I think Ms. O'Brien had just a further supplement to the record, so I'll let her go. Go ahead, Ms. O'Brien.
Just trying to say that when you draft the protection order, we would like to have our expert, John St. Augustine, allowed to also see those records because he's our expert on police procedure and practices.
Okay. The protective order will allow for members of the defense team, including any retained experts, to review the records as well, as long as they're not copied or disseminated beyond that.
Thank you, Your Honor.
And I agree with Ms. Forrest. I think it makes sense to defer further argument and ruling on the motion for sanctions pursuant to Rule 16 until the parties have been able to review the records. I know we're set for pretrial conference on the 22nd, I believe. Otherwise, we could look at just the day before the 21st, if that would work better for the parties.
I'd like to do it much sooner than that, Judge. Well, I guess that's next week, isn't it?
Right. Suppose we can come back Thursday, but that's going to be a relatively quick turnaround.
I could do Thursday.
I would ask for a little bit more time so that I have appropriate amount of time to review the records. I haven't seen them. I'm not on that other case. And Ms. Fritz, who's also my co-counsel, is out this week. So it would just be me kind of sorting through that.
Okay. How's Monday, October 20th at 8:30?
Would it be possible to do towards the end of the docket? I'm not sure how big your docket is that day. We just have a trial prep meeting with
Oh,
Dr.
his
Sina
docket
that
is
was very hard to
huge.
get, and that's scheduled for 9 a.m.
Docket.
Okay.
Virtually, it'll be very quick.
Gotcha. I have a jury trial going and I have a very light docket and
Okay.
I'm under a bit of time pressure to get that trial done. So how's the next day, October 21st at 8:30?
We could accept that.
I could do that.
Okay. Ms. O'Brien, does that work for you?
That's fine. Yes.
Okay. And Ms. Unos, does that work for you, ma'am?
Traveling that day, I think I want to observe more than participate in the hearing just to get an understanding of the court's ruling. So to the extent that I'm available, I will be appearing on WebEx.
Okay. All right. That will be fine. Thank you. Okay. Thank you. So
Will we still do the next day as well? I'm only asking because I have our cellular data expert arranged to be on WebEx on Wednesday, the 22nd.
okay.
For that
We can
motion.
Sounds
we can maintain
fascinating.
the pretrial for the 22nd and
Okay.
to the extent we need a record on that, we can take that then. So take under advisement the defense motion for sanctions based on Rule 16 as well as under 2431-902, the body worn camera statute. I believe we also have a pending motion from the people concerning expert reports, as well as a defense motion in limine. I think it makes sense to take up the motion concerning expert reports, again, given the timing. We'll defer to the parties if we want to look at the motion limine next week as opposed to this morning. I think I'm prepared to take argument on it, but we can also defer that. So let's start with the people's motion for further expert discovery. Ms. Forrest, I'll turn it over to you for any further argument.
Your Honor, I think
I'm sorry to interrupt, Ms. Forrest. Can Ms. Hinojosa speak? Does anybody need?
Oh,
anything
yes,
else?
no, thank you. I should come here at least. Thank you. I think our argument is laid out in our filing, a renewed motion for the expert opinions. What we've received in discovery as for these two expert witnesses is conclusions, but nothing about their opinion or how they reached those conclusions. And we're not asking for, all of the literature that they relied upon in their training or experience, but simply what they're actually going to be testifying to. It works the same way when the people have our own witnesses, that the defense requests this, and we have to make sure that our expert disclosure report contains everything we anticipate the witness is going to testify to. Otherwise, they wouldn't be able to testify to it. And so here, all we have are kind of somewhat vague or very general conclusions, but no understanding of the basis for those conclusions or the underlying reasoning for those conclusions. And so we can't properly prepare for cross-examination if we don't know what the witness is going to testify to. And so we want a further basis for those opinions.
Thank you, Ms. Forrest. Mr. Bibick?
Judge, I've reviewed both of these reports, and in our opinion, these comply with Rule 16. As we've learned from Deputy District Attorney Atherton, the purpose of the rule is to serve the interests of justice and provide sufficient meaningful information to conduct cross-examination, not to continue to require opposing party and its witnesses to author reports or speak to the prosecution until they have no further questions about the witness's area of expertise, or until they understand how each witness fits into the defense's theory of the case. Both of these opinions talk about what the experts looked at, their experience, their training, their review of the discovery in this case. I'm not sure how much more I can give on this. I suppose if the court thinks I need to give more, I'll need some specific guidance as to what that might be.
Okay, thank you, Mr. Bibick. I think I've reviewed the motion filed by the prosecution and the response from the defense, as well as the two attached reports of defense experts, John San Augustine and Mark Hoff.
Foff.
Thank you. Thank you, Ms.
Foff.
O'Brien. Okay, Mark Foff, thank you. In light of the court's order and the direction in the rule, Rule 16, Part 2B. Part 2B does authorize the court to issue orders where if a report was not prepared by an expert in compliance with the other discovery obligations of the rule, court can issue an order that a summary be prepared describing the witness's opinions and the bases and reasons therefore. And the rule goes on to state the intent is to provide sufficient meaningful information to conduct an effective cross-exam. I agree with the prosecution in review of these reports. While they do contain some details and broad disclosures of what materials were reviewed, to the extent that there are any opinions listed, they are quite broad and conclusory. Looking at San Augustine's report, he doesn't specify, for example, what aspects of the chain of custody or investigation are lacking. He simply says all investigation failed to properly preserve, process, and document evidence for all crime scenes with no examples or any direction what that means, failed to accurately document all investigation and processing of evidence. He does point to specific ACSO and post policies. However, there's really nothing in there that would allow for the prosecution meaningful opportunity to prepare for trial or conduct a cross-examination on the points raised by Mr. St. Augustine. Similarly for Mr. Pfaff, it's a vague declaration as to how multiple extractions may impact the reliability of data extracted from a phone. He makes an opinion that the interrogation of Mr. Gomez-Roman was inappropriately conducted, but gives nothing to indicate what best practices he's referencing that were not observed, how any of that impacted the reliability of the statements, again, leaving the people no meaningful opportunity to prepare for cross-examination. So I do find that further disclosures are warranted and authorized by Rule 16, Part 2B. So we'll grant the people's motion in order that the defense provide either an updated summary or updated report as to those two expert witnesses within 7 days by October 21st. Order that they include any specific opinions that they expect the witness to offer to the jury, as well as the specific bases and reasons for that opinion, including any underlying facts or data supporting that opinion. I think largely that portion has been met, given that they're referencing reports and documents within the case. I can do my best, Mr. Bibb, if you have questions as to the court's order. Obviously, I want everyone to be on the same page so parties can comply with the order, but not knowing the specifics of what may be testified to, I don't think I can give a detailed list, but there needs to be more specifics in terms of what the opinions actually are as opposed to the conclusions. So the conclusion that the sheriff's office failed to properly preserve or process evidence is not sufficient. There need to be some intermediate opinion as to what aspects they actually failed to do with specific references to the basis for that opinion. Similarly for Mr. Pfaff, more concrete information as to how multiple extractions may impact the reliability of data and what specific opinions he has concerning the interrogation of Mr. Gomez-Roman, why it did not follow best practices, what those best practices are, and what specific impact that would have on reliability of statements. That's more by way of overview than an exhaustive list, but Mr. Bibick, do you have specific questions or requests for further findings or orders at this time?
I do not, but I better check with my handler, Ms. O'Brien.
No, I was trying to write really fast as you were talking, Judge. You said the best interrogation practices, what they are and how they didn't follow it, and I missed the part about the extractions.
My understanding from at least the first portion, Mr. Pfaff's disclosure, is that he would opine that multiple extractions can impact the reliability of data. Sorry, give me just a moment. Repeated data extractions on a cellular device may impact the reliability or the resultant reliability of the data from each extraction, but doesn't explain how that occurs or what the mechanism is.
Okay. That helps.
Okay. Anything else, Ms. O'Brien? Obviously, I want to clarify.
No, I think I understand.
Okay, Ms. Forrest, any further record there?
No, I understand the court's ruling. I did want to bring up something that wasn't detailed in the people's renewed motion regarding expert disclosures. Given there's also Dr. Dickey, which is the defense's psychologist, and we had requested kind of his testing notes and information and any type of documents from what testing he did with his interview with the defendant. Defense did send us some handwritten notes by that witness, as well as a printout of somewhat the examination testing notes that witness utilized. What I am missing is the interview that their expert very clearly had with the defendant and the defendant's answers in its complete form. Because when reading Dr. Dickey's expert report, he details certain facts, I would say, or things that the defendant is alleged to have said that are not contained anywhere in the prosecution's discovery. So that indicates to me that that information was provided to Dr. Dickey during an interview with the defendant. And more information was given by the defendant to the doctor that led the doctor to come to his conclusions. And we don't have any of those statements anywhere. So again, it's this inability to prepare for cross-examination when the witness is going to come in and testify to an examination that he did, and we are not privy to the information that was learned during that examination.
So just to make sure I understand, Ms. Forrest, you have handwritten notes, but your concern is there's another either documentation of an interview or recorded interview that hasn't been provided?
Or just that it needs to be, whether it exists and it hasn't been provided, or that it needs to be created. The handwritten notes, and I can show the court if you want, I can't read them even. They're illegible, it's very sparse. And so we really don't have the defendant's statements that were provided to this witness during what clearly was an interview with him. And so we're asking for that to be provided and detailed. I don't know if it was recorded. We would want that if it was, of course, but if not, then to have the witness detail what the defendant told him.
Thank you. Ms. O'Brien?
Well, he says in his report exactly that he had an interview with Ivan Gomez-Roman, and he writes in the report what he said, but he did not record it. He doesn't have any other notes. I've asked him, and I don't know what else we could give.
Okay, thank you. And my understanding of the record from Ms. O'Brien is that any record or notes taken from the interview of Mr. Gomez-Roman have been provided in the handwritten notes. The other substance of the interview has been provided in the report. I understand the concern there, Ms. Forrest. That certainly there may be some gaps in terms of what Mr. Gomez-Roman may have related that were not documented. I'll simply order a defense. It sounds like this has already been done, but just confirm with Dr. Dickey that there is no other recording of the interview. My recall, I admit I could be wrong on this, but in terms of the statutory requirement to video and audio record psychological interviews, I believe it only applies to Class 1 felonies. I don't know that that would apply to a Class 2 felony here. If I'm wrong on that, Ms. Forrest can correct me with a notice or motion to reconsider, and I'll consider whether court should take any further action if that statute was not complied with. But otherwise, I don't find that I have a basis at this time to require the defense to reproduce other aspects of the interview, given that there is a report that was created and disclosed to the prosecution. Ms. Forrest, anything further on that?
No, thank you.
Okay, thank you. Ms. O'Brien, anything further on that?
No, Your Honor.
Okay. Okay, folks, do we want to address the motion in limine filed by defense as to Dr. Dickey at this time?
I'm prepared to move forward on that.
Okay, Ms. Forrest? Okay, thank you. Mr. Bibick, I'll let you make a further argument or record on that motion, sir.
Judge, I think the motion speaks for itself.
Okay. Ms. Forrest?
Your Honor, obviously, the credentials of an expert witness, especially one in the medical field, are extremely relevant and important for the jury to hear in order for the jury to determine whether to rely upon that witness's testimony or whether to find that that witness is an expert. This case there's going to be a lot of battling experts, if you will. So the fact that somebody who's purporting to be a medical doctor had their license suspended or revoked or had disciplinary action regarding that during a period of his time for falling below the standard of care is extremely relevant. and the jury should be able to hear about that. I do think it's interesting that the defense argues in their motion in limine that because it has nothing to do with truthfulness, that all of a sudden it's not relevant, when they completely argue the contrary when it comes to other witnesses of the prosecution, for example, CSI Carroll. That's part of the basis of their argument, is that, you know, it goes to integrity or performance of jobs and how the job was handled. So I would ask the court to deny that motion. Dr. Dickey's previous history, his disciplinary action, his inability to abide by this proper standard of care in Colorado in that field is extremely relevant, and the jury should be able to hear that to make their own assessment of which expert to rely upon, if any.
Thank you. Mr. Bibick?
Judge, this involved a treatment protocol of a child back in 2001. There was disagreement over whether or not this was appropriate. The board felt that it fell below the standards, but it had to do with a child. And it had to do with a child who was evidently sexually assaulted. That is totally dissimilar from this case, where we're talking about treatment of an adult, where the purpose of the investigation was to give us some insight as to how his brain was operating at the time of the interrogation shortly after the incident. That's the substance of his testimony. Impeachment evidence in this sort of a case ought to be directed to the witness's credibility rather than to his moral character. People v. Couch, Lawrence v. Taylor, that I cite in my motion. The licensing action is wholly irrelevant to his credibility or qualifications for the opinions rendered in this case. Further, the court must weigh whether the probative value is substantially outweighed by unfair prejudice. The only reason the prosecution wants to bring this up is absolutely for prejudice. It has nothing to do with his truthfulness, his character for truthfulness. It is not a criminal conviction. It is inappropriate in this case. People v. Segovia also tells us that truthfulness must be directly implicated for the impeachment to be admissible. And that licensing action has nothing to do with truthfulness. It has an agreement as to, a disagreement as to the techniques employed. Perhaps they were unusual. Thankfully, I'm not a psychologist, so I don't know, but it is too dissimilar, number one. Number two, has nothing to do with his truthfulness or credibility.
Thank you. I think I've reviewed the motion filed by defense seeking to limit any cross-examination of Dr. Dickey concerning a 2001 disciplinary matter related to what looks like private treatment of a child patient. I think really this is just simply a 403 analysis. Obviously, disciplinary proceedings or actions against an expert, even tangentially related to the field that they're testifying on, may be relevant to determination of credibility, even if it doesn't go directly to truthfulness, may assist the jury in determining or considering the substance of their expert opinion offered. However, here we're talking about what looks like a single instance of professional discipline from 2001, as argued by the defense, in the context of a therapeutic relationship with a child patient, as opposed to forensic psychiatry or psychology in the interview conducted with Mr. Gomez-Roman. So given that it only tangentially relates to the expert's potential qualifications, as well as given the amount of time and the findings laid out from that administrative action in the defense motion, I don't find that, I find that the probative value is limited given the amount of time and the lack of relation between that and the expert opinion being offered. And I do find that the danger of unfair prejudice and confusion of the issues for the jury outweighs that minimum probative value given the record before me. So I will grant the defense motion limine and find that at this time, at least, the 2001 disciplinary action is prohibited by 403. Obviously, Ms. Forrest, if the door is open somehow during the testimony, I'll just ask that the prosecution approach before seeking to elicit that testimony. I'll reconsider in context of evidence if the 403 analysis looks different. Mr. Bibick, anything further on that?
No, thank you.
Ms. Forrest, anything further?
Yes, a question of clarification. I believe that, and I believe I'm remembering this correctly, that Dr. Dickey is no longer a licensed psychologist ever since that event, which would be something we would want to discuss, certainly in voir dire. And so I want to understand better kind of the court's ruling around that. Like, would we still be able to go into that?
I think the fact that he's no longer a practicing psychologist, if that's the case, and how long that's been is still certainly relevant. Getting into the basis for him no longer practicing right now, I'm going to prohibit that based on 403. But again, if the door's open somehow in terms of his testimony or how he's qualified, I'll reconsider that.
Okay.
Does that help, Ms. Forrest?
I think so, yes.
So, Judge, I don't think counsel has a good faith basis to make those allegations. She could have her staff check with Dora and see if he's licensed. And she can do her own research as to whether or not he's still practicing.
Okay. And obviously I expect any attorney asking those questions to have a good faith basis for that question. I'll leave it to the parties as to that. Certainly if there's an objection to Mr. Bibick, I'll take that up contemporaneously. Anything else, Mr. Bibick, on that, sir?
No.
Okay. All right. Thank you, folks. Anything else to address this morning before continuing
Yes.
to the 21st?
Yes.
Ms. O'Brien.
Yes, I think you said maybe we would put off the motion about Dr. Arden, but I think that one might be timely because he's already made a plane reservation. Our problem is that Mr. Gomez-Roman is out of money. We are really limited here. We've already called off one of our experts because we just can't pay him. And so that's why we were asking for him to be able to be on WebEx. Obviously, we'd love to have him here in person. He's a wonderful person. We'd love to see him, but it just is very expensive to have someone fly here from Florida, stay overnight in a hotel, get a car, the whole thing.
Okay. Thank you, Ms. O'Brien. I think it makes sense to address that this morning as well. Ms. Forrest, are you prepared to address that?
Yes.
Okay. I'll take any record from the people.
Your Honor, the people are objecting, given that this is really an expert testimony heavy case. There's pretty much an expert on each side for every issue. It is important for the jury to be able to assess the credibility in person of each expert to determine which testimony that they're going to believe, if any. If this was simply one expert and no others on either side, then maybe that would be different, but it is heightened in this case, and it's important for this witness to be present in front of the jury so that they can make those same determinations that we ask them to do with all other witnesses that are in front of them.
Thank you. I think I've reviewed the defense motion seeking to allow the expert Dr. Arden to testify remotely and the people's objection made today. I think certainly the defense motion does point to some considerations that weigh in favor of allowing remote testimony, that this is a expert testifying to potentially more technical issues, that some credibility determinations can be made just based on the content rather than observation of body language or other facts that are in person. But it does appear that the expert will be testifying as to fairly material aspects of the autopsy conducted and other aspects related to potentially how the death or the shooting occurred in this matter. These are the key issues. I am extremely sensitive to the financial aspect here. Obviously, in an ideal world, Mr. Gomez-Roman would not have to worry about finances when ensuring that he has a full and fair defense. But I do also have to consider the people's right to a fair trial as well, and ensuring that the jury can make appropriate determinations of credibility. Given all of those competing interests, I do find it appropriate to require that Dr. Arden testify in person if he is going to testify on behalf of the defense. So I will deny the motion for remote expert testimony of Dr. Arden. Ms. O'Brien, anything further on that?
No, not on that, Your Honor, but when I was looking through the motions, I found an old one that had, I think, never got ruled on somehow, to exclude expert Jean McAllister. I think that was filed at least 6 months ago.
Okay. Let's see. Can you tell me when that was filed? Oh, I see. June 23rd. I see that from June 23rd of
Okay,
last
you
year.
got it. Yeah, I don't know how that didn't get ruled on, but I don't see a ruling. And I don't remember arguing it.
Okay, give me just a moment. Okay, thank you. I'll take any further argument from defense as to that.
Your Honor, Ms. McAllister is endorsed as a blind expert. A blind expert may bring value to an appropriate case. People v. Cooper, 490 P. 3rd, 420. For instance, it may be appropriate to explain actions counterintuitive to what an ordinary juror may expect, explaining what the social sciences have arguably learned. But there are substantial risks when a blind expert is used to persuade a jury to make findings of historical fact that are not supported by the record. Black letter law tells us only relevant evidence is admissible. Irrelevant evidence is not admissible. The opinions of a blind expert must have some relevance or some fit to the facts of the case. As in any case, expert testimony should be admitted only when the expert's opinions will be helpful to the finder of fact. People v. Valdez, 183 P. 3rd, 720. Helpfulness. The question of helpfulness hinges on whether the proffered testimony is relevant to the particular case, whether there's a fit. And a fit demands more than simple relevance. It requires there be some logical relationship between the proffered testimony and the factual issues involved in the litigation. That is, even if good grounds exist for the expert's opinion, it must be validly and scientifically related to the issues in the case. In the Cooper case I cited, there was no evidence of any improper control over the alleged victim, either physically, emotionally, or economically. No evidence of a, quote, escalating cycle of violence, unquote. No evidence to support the opinion that victims of domestic abuse often stay in abusive relationships and are then subjected to additional abuse. The existence of an intimate relationship alone does not justify the admission of the power and control
Yay, Jude. Yay, thank you. Thank you.
wheel or testimony related thereto, and other expert testimony regarding the characteristics of an abusive intimate relationship, where there is no evidence to support it. Without any such evidence, any minor fit cannot excuse the admission of extensive irrelevant evidence of this type. This is particularly true in a case such as this, as in the Cooper case, where there are no third-party witnesses to the alleged crimes. And in the Cooper case, criminal liability rested entirely on the jury's perception of the credibility of the testifying facts witnesses. There is no
moved
evidence
again.
in this case supportive of what Jean McAllister may say.
Oh,
And
stop.
without that,
There,
there's
enough.
no fit between the facts
I'm
of this
about to have a
case
fit.
and any opinion she might offer. Consequently, we're moving to exclude her.
Thank you. Ms. Forrest?
Your Honor, first, at the outset, just so everyone's on the same page, the people would
I am not allowed to send a cheer to my own channel. I've tried and tried. It will not let me. I just set up right now while you guys were watching court videos. I set up a thing that flashes on the screen for a few seconds when you send a cheer in Twitch. If anybody has one little cheer left, and we can test it. It won't let me test it, or I would. But if anybody has one bit to spend, bits are only one cheer. Sorry, cheers are only one bit. I don't know how much you guys pay for a bit. I get 1 penny off of it. So hopefully you guys aren't spending like $5 on a on a cheer, because I get 1 penny out of it. But if anybody has any cheers and can cheer once, we can test it. Also, if you are, it's too small, but it works, Monica. Monica, cheer. Thank you for the cheers, Monica. Okay, look at that. It works. I can fix it. I can make it red. I can make it bigger. I can fix it. Yes. Anyway, if you guys are watching my stream right now and you're getting ads, and you don't want to see the ads, sorry, if you have an Amazon Prime membership, you get to sub to 1 Twitch channel a month, and you can use that for free, sub to my Twitch and watch the stream with no ads, and it's free. But there, so if you guys are watching and you have Amazon Prime and you're watching ads, you can fix it. Oh yeah, I have YouTube Premium. Videos. I don't know, today I wasn't paying attention to the videos because he's very cute, I'm not gonna lie. But his voice is nice enough. So I was just listening to him talk while I was making this little thing. Now I'm gonna make it better. Now I'm gonna make it bigger. Now when someone sends me a cheer in Twitch, the stream over is gonna know.
Only be putting Ms. McAllister on the stand to testify if the door had opened to some 404B evidence that we had litigated previously in this case. In that event, then it is helpful and relevant to the jury to inform them about dynamics of domestic violence. For example, why a victim would stay in a marriage with someone who was physically violent with them. That is something that is a difficult concept for lay people, for jurors to understand. And so Ms. McAllister would help to inform them of that and the nature and dynamics within that type of relationship. It's really going to be dependent upon whether the door is opened and to what information the door is open to. And then we can re-raise or rediscuss the limits of Ms. McAllister's testimony at that time. But that is our intention. And I believe that given the fact that Ms. McAllister would be a blind or general expert that really limits or takes down any prejudice or any argument against having the witness testify as to general concepts of domestic violence, that will simply inform the jury of how to rationalize the evidence.
Thank you. Thank you, folks. I've re-reviewed the motion, and I looked over my notes, and it looked like there was some deferred ruling on that back in September of 2024, and then following the endorsement of mental condition defense. I think that got lost in the shuffle, so my apologies on that. At this time, I agree with the people. It looks like it's not yet ripe or too early for the court to make specific findings. Obviously, I agree with Mr. Bibick that pursuant to People v. Cooper, any generalized expert testimony offered must have proper fit to the specific facts of the case. People have indicated they were not intending to call Ms. McAllister in their case in chief unless the door is open to the 404B evidence that the court has already issued rulings on. So if we are at a time when the people believe that the door has been opened and intend to call Ms. McAllister, we'll hold additional brief hearing outside the presence of the jury to take any further objections as to her proposed testimony. I'll make findings under Cooper as to proper fit to the facts of the case. But unfortunately, at this time, I don't think I can make any further specific rulings until we're at that stage. Mr. Bibick, Ms. O'Brien, anything further on that?
Not on that.
Okay.
No, Your
Ms.
Honor.
Forrest? Okay. Ms. Forrest, anything further there?
No, thank you.
Okay. Mr. Bibick, you implied there's some additional issues to address there?
When will we be discussing sanctions?
On the 21st.
Thank you.
Okay. Thank you. Anything further from defense this morning?
No,
No,
Your
thank you.
Okay. Ms. Forrest, anything else from people?
I did just want to make a VRA record that I do see some of the victim's family members on WebEx. Typically, the victim's mother requires a interpreter. We had emailed the victim's attorney who represents them yesterday to let them know about today's court date because it was set very quickly. I also asked if the attorney, if the victims would be needing an interpreter, and he indicated yes to have us arrange for one. I did have an interpreter come in this morning, and she would need to call the victims on the phone to be able to interpret for them via WebEx. She called the phone number we have for the victim's mother and there was no answer. And then we tried one other family member and were not able to reach them. And so the interpreter had to leave to go to another courtroom. But I just wanted to make that record so everyone understood what happened today.
Okay. All right. Thank you. And I'll let everyone know. Thank you for being present. This matter was added on pretty shortly, just given some of the new developments that were discussed this morning. So sorry for the short notice. We'll be back on October 21st at 8:30 to take up the motion concerning sanctions from the defense. Make sure to get the disclosures as to Ms. Carroll out today and Ms. Janchek out tomorrow.
And we'll see you later this afternoon, informally.
Yes. All right. Thank you, folks.
Thank you.
And I have a preliminary hearing going this afternoon, but I should be able to get to the records over lunch. So we'll just have them ready here in court so folks can just come up and approach Ms. Daly to grab those. Okay. Thank you, everyone.
Thank you.
Thank you. Mr. Brockett?
Yes, Your Honor, if we could call the Puentes Lira matter.
Yes, this is 25 CR 2051, People versus Puentes Lira. I'll take entries starting with the people.
Aaron Brunskill for the people.
Aaron Brockett on behalf of Mr. Puentes Lira. Your Honor, he is the call-in user.
Okay. Mr. Puentes Lira, can you hear us okay, sir?
Yes, I can hear you guys perfectly. Good morning, by the way.
Okay, good morning. This matter comes on for arraignments. Mr. Brockett, I don't know if there was approval for a phone appearance. I'll let you make a record as to that, sir.
Yes, Your Honor, I did receive a, well, I'll say that me and Mr. Puentes Lira have been in good communication, talking over the last couple days, and I did receive a voicemail early this morning explaining that there were car troubles. I believe he had a tire blowout, and so wasn't able to make it here. So I did provide him with the WebEx call-in number so he could at least appear that way. Our original plan was to ask for a continuance. We did just receive a advisement back on some potential collateral consequences. So we were needing to look into that further and perhaps discuss some of that with the district attorney. So I would ask the court to consider just staying any type of warrant until the next court date, or if we want to set an earlier stay of execution than what the court date would typically be, we could do that as well.
Thank you. Mr. Brunskill?
Your Honor, according to the SRP report that was filed, the defendant has an active warrant out of Boulder County. As I've not been provided any sort of proof about car troubles this morning, I'm more inclined to believe that his failure to appear in person today is out of a desire to avoid being arrested on that warrant. I don't believe it would be appropriate for this court to essentially help the defendant avoid an active warrant by authorizing his appearance by WebEx today. I'd ask the court to issue a warrant based on his failure to appear in person without any sort of pre-authorization to appear by phone.
And just a second to look at that, because I know it's been quite some time since any report was filed from them, so I don't know if that's still accurate information or if we have the case number.
Okay, thank you. I'll give you a chance to review that. I am having trouble finding that. And folks, I apologize. I'd like to pass this just for a moment while folks look at that. I just need to take a short break.
Sure.
Okay.
We
So Mr. Pointeslayer, please stay
finally
on the line. We're
had
gonna call your case back up in just a minute, okay?
a great shot of the judge, and I was over here trying to fix my Cheers thing. Yeah. Okay, so just so you know, when I went to work yesterday, my mouse was touching the top bar. So this little black box in the top left, it's there for all 5 hours and 28 minutes of this clip before it stopped recording.
Yes, of course. Thank you.
Judge, when you say take a break, you wait. Damn it, we had the perfect picture of him. Maybe when he comes back to break, all of these other boxes will be gone. What do you think? Let's get him back. Come back. Brett.
So,
Hi,
Mr.
Brett.
Pointeslayer, you'll need to appear in person in Division Q at 8:30 on October 16th at 8:30. Otherwise, a warrant will go active for your arrest. Okay, sir?
I understand.
Okay. Mr. Brock, anything further on that?
No, Your Honor, thank you.
Okay. Mr. Brunskill, anything further?
No, thank you.
Okay. So I think functionally we'll just be set for status or arraignment to Thursday, the 16th at 8:30. Anything else from either party?
No, Your Honor.
Okay.
Thank you.
All right. We'll see you then, sir. Thank you.
Thank you.
Ms. Cantrell?
Ready to call Mr. Cervantes' case.
Okay. Thank you. Morning, folks. Thanks for your patience. Sorry, this is a long morning. This is
Call that case because I believe the Cervantes matter will take a while. We have Mr. Vance here. It looks like he's pro se still.
okay. Thank you. And my apologies there, Mr. Cervantes. We're going to call this case just could be a little shorter. Ms. Cantrell, you still on this matter? Or is this a
It's a reapply.
reapply? Okay. All right. Thank you, Mr. Vance, for your patience. You can come on up to the podium, sir. This is 25 CR 2408, People versus Vance. I'll take entries starting with the people.
Aaron Brunskill for the people.
Thank you. Mr. Vance appears out of custody for arraignments. Mr. Vance, are you planning to apply for the public defender and have them?
Yeah, the person that gave me the ride the last time I was up here couldn't stay, and I tried to do it online, and I could only get so far. So I'm going to have to get in there.
Okay.
And do that.
Okay. Thank you. I'll order that you get the application in today before you leave, just to make sure, because it does take them a few weeks to process everything. So I want to avoid any further delays. Mr. Brunskill, any objection to continuing the arraignment for that purpose?
No.
Okay. All right. We'll get you a new date, and then there should be an application in the podium there if you don't have one already.
How is Tuesday, November 25th at 8:30?
I'm open, Your Honor.
That works.
Okay. Thank you. Your bond will continue then to Tuesday, November 25th at 8:30. If you need to write down, there should be a pen on the podium at the top there.
Thank you.
Okay. Thanks, sir. We'll see you back then.
All right. Thank you.
Thank you.
You have a great day.
Thanks. You too. Okay. Mr. Fontes, you can come on up. Okay. We are calling 24 CR 1009, People versus Cervantes. I'll take entries starting with the people.
Eleanor Lansbaum for the people, Your Honor.
Tempest Cantrell covering for Kerry Coble on Mr. Cervantes' behalf. He's out of custody to my left, and I'll note that his uncle, Santos Rodriguez, is also present.
I need to do something really quick. So don't just, oh, that's almost a smile right there. Almost. That's a good pause. Right there is a good pause. Anyway, I need to do something real quick. So the screen is going to show a box. Just give me 2 seconds and it'll be gone.
Thank you. Good morning, folks. This matter comes on for sentencing. Ms. Cantrell, are you ready to proceed?
We are ready to proceed to sentencing.
Thank you. And are the people ready to proceed?
Yes, Your Honor.
Okay. Thank you. I have reviewed the PSI in this matter. Ms. Cantrell, I'll turn it over to you.
Yes, Judge, I'm asking that the court follow the stipulated agreement between the parties. I'm asking that the court sentence Mr. Cervantes to a year of probation. As I mentioned, his uncle Santos Rodriguez is here, as well as his his mom is also here. He has a lot of family support. His uncle has acted as a parent to him. At the time that this happened, Mr. Cervantes was not taking his medication, and he's diagnosed as having schizophrenia. And as the court knows, he was incompetent for a period. Right now, he is on his medication and doing well. The court can see that he has minimal criminal history. So I believe that this is an appropriate disposition. As it relates to the terms and conditions of probation for the court to impose, I guess before I go into a long record, is the court's understanding of what the PSI and the OSC is asking is that even though this is not an SOISP case, that the court still impose the additional conditions for sex offenders?
I don't know if this was categorized as SOISP, but I did note the request for special condition 23 being imposed in the PSI.
So I think it says if granted probation, the defendant will be supervised under the sex offender terms and probations, but not on sex offender intensive supervision probation. And then they included the pre-printed form that has the additional conditions for probation, including the special additional condition 23. So I guess first I'd just like to address what the PSI is talking about with those specific terms. I'm asking that the court has to make findings for each term and condition of probation that it's reasonably related to rehabilitation. I'm asking that the court not impose condition 19 from the additional condition of supervisions for adult sex offenders. In this case, if the court is going to impose one of those conditions from the additional conditions of supervision for adult sex offenders, I'm asking that the court impose condition 5 as opposed to condition 19. I'm also asking that the court make a finding that the probation cannot impose the computer use agreement unless this court orders Mr. Cervantes to comply with the computer use agreement. I'm also asking that the court make a finding that there are no case-specific reasons for the additional conditions, for additional condition number 23, which would effectively ban Mr. Cervantes from using the internet, except in very limited circumstances. In support for that, I would just state that the form that is provided in the PSI and the OSC is a pre-printed form that was created by judicial. It's by no means required that the court impose all these conditions from the additional conditions for sex offenders. And in fact, the expectation is that the court not just simply impose a blanket imposition of these conditions. The court must make factual findings that support how conditions are related to rehabilitation. In reviewing the the conditions that are provided, my reading of that is that the only statutorily required conditions that the court must impose is as it relates to registration. The other conditions on here are not necessarily statutorily required, except as it relates to treatment, but are up to the court to decide whether those should be imposed if they're reasonably related to treatment. Proposed condition 19 states that Mr. Cervantes would not use computer systems or internet capable devices, and that he would follow the computer use agreement, and that he would allow someone from probation to conduct searches of his computer or other electronic devices at any time without probable cause or reason to believe that he had violated the agreement. There's no support for why condition 19 should be imposed in Mr. Cervantes' sentence. I did a quick search through the OSC and the PSI. The word internet is not used anywhere in that evaluation. So they don't even opine as to how or whether the internet was involved. So there's no factual support in the record for him to be limited from having access to the internet. That also goes to additional condition number 23. The court has to find that there are case-specific reasons for that condition to be imposed, and those just are not present in the record here. This case doesn't involve the internet. It doesn't involve technology really at all, and so there's no support. In these cases, these sex cases I've done, it seems that probation is a standard condition that probation is recommending, or the writers are recommending every single time, regardless of what the facts are, is that the court impose condition 23. That's not what the legislature intended. That doesn't match up with what probation is designed for, which is to provide conditions that are reasonably related to Mr. Cervantes' rehabilitation. And I stated, there's no evidence of electronic devices being used. The court is going to impose condition 19, then I'm asking that the court narrowly tailor that. I don't believe that would be appropriate though, because condition 5 does already exist if the court's going to impose any restrictions on his internet use. Due to the possible breadth of these conditions, a sentencing court must meaningfully evaluate and make factual findings about the precise nature of electronic monitoring that is needed and any alternative means by which it may be accomplished. It's not sufficient to state that someone is a sex offender, their case involved technology, and therefore continuous monitoring is permitted. And we don't even have that fact here of technology being involved. The Colorado Court of Appeals has addressed the issue of continuous unfettered monitoring of a person's electronic devices and internet use while on probation. And they concluded that in People versus Sylvanic, a 2023 Colorado Court of Appeals case, that the district court erred by requiring continued unfettered monitoring of someone's devices while they were on probation. And in that case, it involved a cell phone. A cell phone was used as part of the crime. And even in that case, the court found that allowing continuous unfettered monitoring would be appropriate and inconsistent with what probation should be. And beyond that, violates the Fourth Amendment by permitting searches without probable cause.
It would be easy for us to say yes. It would be easy to say that she's defending a person like that. But we do not have enough information. He is innocent until proven guilty, except in my mind. He's guilty in my mind.
So if the court is going to impose any restrictions on Mr. Cervantes' access to the internet, either through condition 5, condition 19, or special additional condition 23, then the court has to narrowly tailor that to match the facts or in the circumstances of Mr. Cervantes' case, and not just simply issue a blanket ban that would prevent him from being able to access the internet. As I previously stated, it's not related to his rehabilitation. Beyond that, it's unduly punitive. The internet is not a luxury, it's a necessity for modern life. Mr. Cervantes is on probation now and uses Uber and Lyft to be able to get to probation.
It's not a necessity. I could totally live without internet. Totally. I would be perfectly fine because I live in Lancaster, Pennsylvania. I would just move to the Amish farm and live a nice life. They don't have internet.
As his appointments now, if the court enters...
die in an hour, within an hour. First off, oh, never mind. I was going to say, first off, everybody would know because I would complain to the entire world. But I couldn't because I don't have internet. That would not be a quiet go into the night for me. If my internet was gone, I wouldn't make it an hour. My internet goes down for a minute, and I start to put on my old house on the prairie, that Little House on the Prairie, costume. Got no internet. Let's go churn some butter. Ma, you're making those biscuits. The internet I need.
An order saying he can't have access to the internet or cell phone or anything similar to that. Mr. Cervantes can't use Uber anymore. He can't access the internet at all. And the SOMB board has recognized in its most recent draft on draft on evaluating risk factors for internet access and electronic monitoring within SOMB treatment and supervision. They created a working group to update the standards for internet use for sex offenders because SOMB
I live in
recognized that
Lancaster.
using the internet is a necessity in modern life and not a luxury, and that courts need to take into account the specific facts and whether those relate to the offense in deciding whether to limit someone's access to having the internet. As it relates to the computer use agreement, I'm asking that the court not impose the computer use agreement. In addition, I'm asking that the court bar probation from requiring Mr. Cervantes to comply with this agreement unless it is explicitly part of this court's sentence. When this court sentences someone, the court imposes certain terms and conditions. When that person gets to probation, they're required to sign a computer use agreement that includes additional terms and additional requirements that limit Mr. Cervantes' access to the internet. And it's my position that that's not part of his sentence. It's not a required part of his sentence. And if the court doesn't impose that, then Mr. Cervantes does not have to follow requirements from probation unless the court says.
First off, JK, I promise you, I always make sounds. Constantly. I am constantly making noise throughout this world. I cannot shut up.
That if the court says if the court says that Mr. Cervantes has to follow the computer use agreement, if probation finds it to be appropriate, then yes, Mr. Cervantes would have to follow that computer use agreement. If the court does not mention the computer use agreement or include that as part of its sentence, probation cannot then come back later at his first appointment, ask him to follow this computer use agreement, and then later ask to revoke his probation on the basis that he's not following the computer use agreement. As I stated previously, though, the court can only impose this condition if it narrowly tailors those conditions to a legitimate purpose of probation. I've said it tons of times, but this case has nothing to do with electronics or the computer or anything. The evaluator didn't take any time to ask Mr. Cervantes those questions about how he uses the internet, when he uses the internet. Does he use the internet for pornography? Does he use the internet for getting to work? Those things just weren't asked, and there's not support in the record to limit his use of electronics or his use of any computer. As I stated previously, the form that's provided in the OSE is a pre-printed form that's provided by the Judicial Department. There has been research done with SOMB providers who stated that over a third of SOMB providers believed that, sorry, not SOMB providers, probation officers believed that it was required that all of these conditions be imposed, and that it was not just a stock form that could be changed or modified depending on an individual's own circumstances, but that it had all of those conditions had to be imposed, and that's simply not correct. Finally, I'm asking that the court find there are no case-specific reasons to impose any special additional conditions. Specifically, the evaluation asks that the court impose condition 23, which would further limit Mr. Cervantes' access to the internet unless his community supervision team allows him to be able to access that. Again, there's no support in the record for that. Just because someone is convicted of a sex offense does not mean that all of their rights are taken away, that probation can be so intrusive that it literally monitors every aspect of Mr. Cervantes's life. Instead, the district court must meaningfully evaluate and make factual findings about the precise nature of electronic monitoring and any alternative means by which it may be accomplished. As I stated previously, Mr. Cervantes uses the internet frequently in order to be able to live everyday life. Everyone does that. So if the court limits his ability to access the internet through conditions 5, 19, or 23, then Mr. Cervantes won't be able to engage in life the way he was previously. He won't be able to apply for jobs. He won't be able to use a job that has a computer. He won't be able to order things online. He won't be able to buy a plane ticket. He won't be able to do many of the things that are just regular things in everyday life. And considering he's pleading guilty to a Class 1 misdemeanor, that level of restriction does not compare with the level of crime that he's pleading guilty to. So I'm asking that the court not impose any of the conditions related to 5, 19, or 23, but if the court is going to impose those, I'm asking that the court make case-specific findings about why those conditions can be imposed. And I'm asking that the court narrowly tailor those to match Mr. Cervantes' specific circumstances, or in the alternative, find alternate means to be able to impose restrictions that would accomplish the same goal. I'm also asking that the court not impose conditions 10 and 11 about changing his residence and abiding by curfews. I'm asking that the court not impose condition 8, where it states that he will inform his probation officer of his sexual or romantic relationships. I'm asking that the court modify condition number 13 to remove the last phrase that states that he will, quote, successfully complete the program to the satisfaction of the probation officer in consultation with the community supervision team. That's a nebulous standard that is not said. It's not you complete your treatment program and you get off. It's whether or not your probation officer decides you have completed this to their satisfaction, and then you can be released from it. And I'll just note, probation officers are not treatment providers. They don't work with the standards. Yes, that it's something that they work with frequently every day, but they're not the person that's deciding, yes, this person has completed all of their treatment. So he could go through treatment. His treatment provider could say, yes, he's completed the treatment to my satisfaction. But if the probation officer believes he hasn't completed it to his satisfaction, then that's somehow grounds for a revocation. I'm asking that the court not impose that portion. I'll note that in other cases where there's treatment, it's not the treatment in the term and condition for probation does not say that they will complete domestic violence evaluation and treatment to the satisfaction of their probation officer. They will complete alcohol evaluation and treatment to the satisfaction of their probation officer. So I'm asking that the court remove or not impose that requirement. Finally, I would just note from the PSI that the PSI claims that, or OSC claims that Mr. Cervantes has a high risk of reoffending. They put high in there without putting what the percentage is of reoffending. A high percentage of reoffending is less than 5%. And so while that might be high to them, if we're looking at that number in actually hearing that number, it's a very low percentage of what it could be. So I'm asking that the court impose the probationary sentence. I'm asking that the court fashion probation terms and conditions that it finds to be appropriate for Mr. Cervantes' circumstances. I'm asking that the court not impose condition 23 specifically, because if the court is going to impose that, then I ask that the court provide the case-specific reasons for why it is imposing that in Mr. Cervantes' situation. And unless the court has any questions, that's all I have.
Thank you, Ms. Cantrell. Ms. Lansbaum?
Your Honor, first of all, for a VRA record, the father of the child victim, as well as one of the victims themselves, Wilmer, attempted to log on this morning. He was not successful. He is comfortable with us proceeding to sentencing without him. He
Madam,
did,
I agree.
however, want to express he does not agree with probation. He is asking that the court impose a carceral sentence. His concern is that Mr. Cervantes is a danger to the community, should not be allowed to be free, and he is very concerned that Mr. Cervantes could and will do this to someone else and to another child specifically. So that's as far as VRA record goes. As far as a brief factual basis for some context here, Mr. Cervantes was located in a Walmart masturbating. His pants were down. 3 individuals saw his penis. 2 of them were adults. 1 was a 10-year-old child. Mr. Cervantes was, quote, shaking it. By it, I mean his penis, at these 3 witnesses. Mr. Cervantes was arrested inside of the Walmart. He first said that he was looking for his paycheck because he worked at the Walmart. Mr. Cervantes had not worked at the Walmart in upwards of 10 years. He then said that he wasn't doing anything. However, while being transported to the jail, he did say, quote, all I did was stretch my penile. I do that at home. I can't do it at Walmart. He is also swabbed for DNA at the police station. And he says, quote, it's a felony for me just standing there and grabbing my penis. So Mr. Cervantes is distinctly aware of what he has done, what has happened. He knows that it's about his penis. He knows that it's about him touching his penis at the Walmart. This PSI is clear as mud. In some instances, Mr. Cervantes doesn't allow probation to follow up with questions that they have. In some instances, he denies things that are easily proved with contrary material, such as he doesn't drink. He then cannot explain how he has 2 DUIs and also tested positive for alcohol while in SRP pending this case. He has a history of cases. It is not significantly large, but there are prior convictions here. Specifically, there are prior convictions that at one point had a sexual factual basis. In 2009, Mr. Cervantes pled guilty to a 3rd-degree assault, knowing or reckless causing injury. It was at that point a sexual case. The victim in that case was 12. This is not the first time Mr. Cervantes has encountered a minor in a sexual context. There's little to no accountability in the PSI either. He states that there is no real impact on the victim. He then says that he doesn't want to speculate. He says he hasn't done anything wrong. And there's little to no accountability here. And that is particularly concerning because it does lead into his risk of reoffending. And the court's well aware of that individuals who are in denial.
I wonder. Okay. I wonder what the charges would have been if it were just 2 adults that came upon him. Now, I don't know what's going on with my camera. It happened yesterday too. It's just, but this guy is getting completely nailed for, being a child predator now. Because there happened to be a child with those 2 adults. If he was just with just 2 adults came and saw what he was doing, how different the charges would have been. I don't know. This one is weird.
Are at a higher risk of reoffending. And the PSI does believe that he has a high risk for sexually reoffending, not just reoffending and being in front of this court for a DUI or punching someone, but for sexually reoffending. And that's important for the court to take notice of. Additionally, he states when he's asked if he needs to complete offense-specific treatment, he says, quote, no, I really don't believe in being here. And he says that he will participate if that's what's required. He doesn't believe in being here? That's a
what
real
I say at
question that I
work.
have.
I don't believe in being here, but I will participate at work if that's what's required of me. Come on, camera. Oh, well, I just broke the whole camera. Hold on, I broke my mouse. Now I can't press play.
If he doesn't believe he should be here, what exactly should be happening?
Hi, guys.
We are here to hold Mr. Cervantes
I
accountable.
fixed it.
And he is going, I imagine that the court is going to be sentencing him to probation. However, the lack of accountability expressed throughout this PSI and the OSC are extremely concerning to the people, particularly because they all lead to one conclusion, and that is Mr. Cervantes either cannot or will not
Looks like
accept
wooden
the
pants.
gravity of the offense, the individuals who are affected by this, and the fact that he now has to face consequences for masturbating in public in front of a 10-year-old. As far as the recommendations here, I'll start with the OSC because I think that that's a little clearer. The OSC is making a variety of recommendations. It is a total of 9 recommendations. I would draw the court's attention to recommendation number 7, which states Mr. Cervantes should be restricted from accessing, viewing, or purchasing pornography until his community supervision team deems it appropriate. Further, internet use should be monitored or restricted until his community supervision team deems it appropriate. And Your Honor, I recognize that this is not a case where Mr. Cervantes is on the internet. I recognize that. However, I also recognize that after an individualized meeting and conversation with Mr. Cervantes, a licensed clinical social worker who is a SOMB full operating evaluator is recommending that his internet access at bare minimum be restricted. They do feel that there is a point to that. There is a concern here, and it's not just in a pre-printed form, it's after an individualized conversation with Mr. Cervantes. I would also point the court to point number 6, just above that, where it states that he will, quote, likely require additional support from his community supervision team to be successful. And I understand that some of these restrictions recommended by the PSI in the form which goes into a variety of conditions. These are additional supports. They seem restrictive, but they are supports. They are to ensure the safety of the community. And if and when Mr. Cervantes is able to accept that, they're to ensure Mr. Cervantes' successful completion of treatment here. I would note that Ms. Cantrell is specifically objecting to 10, 11, 8, and requesting.
Poor Brett. Does your shoulders hurt? Brett. Hey, Brett. Does your shoulders hurt? Could I help you out with that?
To modify 13. I'll start with 13. I am asking that the court, should the court choose to impose this term, I'm asking that the court leave it as it's appropriate. There's a reason that there are standards, understanding that probation is not necessarily always the treatment provider. However, simply showing up and doing absolutely none of the work is not successful completion. That's not a way that's one way that people think that they complete their probationary terms. However, that's not the way that people are successful on probation. It will do nothing to the community if Mr. Cervantes just shows up and does nothing more. As far as 10 and 11 go, I would object to the court striking them. They are part of the standard terms, conditions that are required by SOMB standards, which is required to impose by probation. As far as term 8 goes, I am also asking that the court keep term 8. I disagree with counsel that 5 and 19 are duplicative of each other. They They're not mutually exclusive. One involves living with children and one involves being able to access the internet. So I do disagree that 5 and 19, if the court imposes 5, the court should not necessarily impose 0.19. I'm asking that the court impose both. I recognize that he might use Lyft or Uber, and I recognize that there is a burden being placed on him. However, there's a burden for a reason. Mr. Cervantes is accepting this plea. He is accepting at least some level of responsibility for his actions of exposing himself and masturbating in front of a 10-year-old as well as 2 adults. There's a burden, yes. But that's because he's here today and he did what he did. He's pled guilty to it at this point. So, and this is not monitoring of the internet infinitum. This is not monitoring of his internet usage, even for necessarily even the entire term of his probation. However, it is restricting and monitoring his internet usage unless and until his supervised team, his team that is supervising him in the community, deems that it is appropriate. And I would ask that the court impose that because they are the professionals. We are here talking about probation, but we are not probation officers. We're not SOMB enforcers. We're not treatment providers. They are determining that this is a term that they feel is
You don't know
appropriate,
me.
as highlighted by the OSC. And I am asking that the court impose all of the conditions. As far as a term of probation, counsel is asking for a year. I'm asking for the court to impose a longer term. From a practical standpoint, I don't think it's feasible for Mr. Cervantes to complete his probationary term within a year, especially not one with the admittedly rigorous terms of SOMB supervision. So I am asking that the court consider a longer term than 1 year. And if I could have just one moment, please.
Of course.
You mean you have more words? You've already had a lot of words, honey. A lot.
That's all, Your Honor. Thank you.
Okay, thank you. If you want to respond.
I just need to
briefly.
supplement my record.
Thank you.
I'm not sure, I just want to make my record clear. This is a non-SOISP plea, and this form is made up by judicial as a form to help judges know what terms that they should apply in SOISP. Ms. Lansbaum just said that all these terms are required. There's no statutory requirements for most of these requirements. These are recommendations from the SOMB standards that come up frequently in these cases. And that's my entire argument, is that the court has to look at his case and say, did his case involve the internet? Yes or no? If it involve the internet? Okay, how can we narrowly tailor these restrictions to make sure that he's not using the internet to commit crimes in the future? That's my point. If it didn't involve the internet, then in my opinion, that's where the analysis should stop.
I think I agree with her. This really has nothing to do with the internet, anything on the internet with children at all. Absolutely nothing happened on the internet. He wasn't stalking children in any way, shape, or form. He just wasn't. He did something in public and a child happened to be there. I mean, yeah, he should have known there were children in Walmart. There's children in Walmart. But I just don't think that they should cut off his internet. I don't think that's legal. I don't think that did that. That wasn't his crime.
There's no record, there's no evidence in this record that the internet was used. And so the court doesn't have any really basis for imposing those conditions. I just wanted to be clear that this form, it's not required that the court impose these conditions. It is not statutorily required. If the court wanted to change the standard terms and conditions on a DUI from what the standard.
But that anyone knows of, you're right. He could be at home doing that. He could be. But this is America. And you can't just strip rights away from someone like that for you. I mean, he had to have committed a crime like that. You can't just say I don't like this guy, he's a creep, so we're gonna strip away his rights. He did break the law, and he should get punished accordingly, and not because, you know, I have no idea why they're trying to strip the internet away from him. Do I want him to have the internet personally? No. Do I want him to be outside of jail personally? No. But this is America, so I don't even know why they're trying to do that.
Form says, the court could say, I'm going to do that. I'm going to change these terms. I'm not going to include this. I want you to do this instead. Because the court is uniquely positioned to understand both the law, the standards, Mr. Cervantes' position, and then make a decision about what those conditions should be. Probation is not. And that's why these are recommendations to the court, because the court can look at the empirical evidence, can look at Mr. Cervantes' position and what the OSC says, and fashion a sentence based off of that. Not just saying, oh yeah, we're going to go with every single thing that the evaluation recommended. I've
Cut
never
something
seen an
off?
OSC
Yes,
that does not recommend
absolutely.
condition 23 being imposed. So for probation or Ms. Lansbaum to stand up here and say that they've given some very very detailed thought process into whether or not someone should not be able to use the internet, I categorically disagree with that. Ms. Lansbaum mentioned conditions 5 and conditions 19. Condition 5, from the standard terms and conditions of probation, regular, non-sex, that we give to everyone, says that you will submit to search when there's probable cause. That condition, in my mind, is sufficient to cover any searches that probation would want to do of Mr. Cervantes's items. And that's the condition that I'm asking that the court impose. Condition 5 of the SOISP terms is about children. Those two
That's
things
right.
obviously.
If he is on probation, they can look at his computer, his phone, his tablet anytime they want. They can do that. That covers it. It does.
Don't relate to each other. Condition 5 from the standard terms and conditions relates to searches, and condition 19 from the SOISP relates to searches. And so I just want that to be clear, because it's crazy to me to say that all of these are required when the law is, and the SOMB standards and all the evidence, if the time is taken to look into it, shows that these standards are not required to be imposed blanket for every single sex offender. How does being a hitchhiker or Mr. Cervantes picking up hitchhikers relate to him pulling out his penis in a store? It doesn't. Is that something we might not want a sex offender doing? Okay, yes, maybe. But is it reasonably related to his rehabilitation? No. Just because he pleads to a sex offense doesn't mean we get to come in here and add all these conditions just because he's pleading to a sex offense. She offered him a misdemeanor off of a felony, and it's a sex offense. And so we shouldn't be having these extremely wide sweeping.
I didn't know that. So if I burglarize the house next door, I'm not allowed to drink alcohol anymore? Even if alcohol wasn't involved at all, they say no alcohol? I didn't know that. I didn't know they could do that. Oh, I have kettle corn. I still have it. Of course, I didn't eat that whole bag. Zach, thank you so much. Thank you. And I didn't know that you couldn't drink alcohol at all at any probation. That's crazy. That's why I'm not on probation. I couldn't cut it. I'm not cut out for probation.
Conditions that are going to really just cause him to come back on a revocation.
It's standard. We hear it all the time because almost all crimes involve alcohol, drugs. Almost everything we see involves alcohol and drugs. When's the last time we saw just someone stealing a bike? You know, getting on probation for stealing a bike. I gotta find more bike stealing cases.
When he can't go to his probation appointments because he can't use Uber. And so I just want that to be clear. I also forgot to state that Mr. Cervantes' uncle, Mr. Rodriguez, would like to make a statement to the court.
Okay, thank you. Mr. Rodriguez?
Oh gosh,
Your
no,
Honor,
I don't want to hear this.
I know Carlos since he's a baby. He's never seen nothing what's going on with all this stuff with this case. Mom, she don't drive. Carlos, we don't let him drive because he's schizophrenic. But I know him since he's a baby. He's never done anything like this. I don't know if there was misunderstanding. Carlos, we were at the store. He said, I'm gonna go use the bathroom. I guess he went in the back of the store on the alley at Walmart and went and used the bathroom there. That's when the cops came over and but otherwise, he's always been, I mean, I never seen him do anything like this, you know, with what they said that they saw us doing, but like, so they gotta get an Uber so he could go to his, to his drug test. They gotta go, mom don't drive, me, I gotta work, so, you know, to keep the house, you know, but the thing is, I never seen anything, you know, I know him since he's a baby and never done anything like this. Yeah, if that's the only way they travel, they catch the Uber. I work for Collins, so I don't have no time to take them to their
And now I gotta ask, if you're schizophrenic, you don't drive car? That doesn't, I don't know. I don't know why that would that stop you from driving a car? Would it? Or is it something else that I missed while I was getting my popcorn?
drug test, because he's got to go to drug test almost once a week. They've been doing that, or twice a month. So, but he's got to do that, and then he's got a call. So he's been doing good because he's got that schizophrenia. So it makes him hard. They're really hard to understand him. You know, a person that has schizophrenia, most of them, they live on the streets because they're hard to control. Carlos, he's been doing good. It took me years and years to understand how that schizophrenia works, but he's doing good. He's a good kid, and I mean, we love him, and we never seen him do anything like what they said they saw at Walmart. But,
Okay, pause.
if you
Stop. Time out. So how does this ever get fixed? Okay, medicate him. Okay, medicate him. Would that stop him? Like, how does this get fixed for real so that he never pulls out his penis in Walmart again? What happens with this guy to fix it completely? I mean, if he has no penis, he can't do it. So I'm supportive of. I am supportive of that, but there has. So therapy, obviously he needs to see a psychiatrist, psychologist, therapist, and medication. And so is that it? Mental health? Like, this is one of those where, what does prison do? I don't think, did I hear that prison was on the table? I just heard probation. I don't know what's on the table. I don't know what they're thinking about as for a sentence. But yeah, okay, all four of them. Bobby, we watch court cases every single day. And if the men would lose their privilege to that item, when they misuse that item, things would go drastically down. Oh yes, I've seen A Clockwork Orange. Have I ever seen it? But when she was properly medicated, she became a different person. Like, better? Like, meds worked? So if he had medication and therapy, would that fix it? Would he not pull his penis out in Walmart anymore? Or is he going to do that because that's the type of person that he is? I don't know, Bobby. I think it would scare a lot of men off. I think a lot of men would stop punching a woman if they didn't have a hand. And then a lot of men would stop punching women if this guy lost his hands because he punched a woman. But that's just what I think. Then, and that'll never happen. I don't know how old he is. I don't know.
I think if you please help us out, you make your own decision.
Because he doesn't feel like he did anything wrong. Definitely. So there's nothing that happened at all today that makes me think he is never going to do this again, ever. No, because he doesn't think he did anything wrong at all. All four of them, Bobby? I don't know. I don't know. It's not a national crisis that women are beating their husbands. We don't see cases. We watch these court dockets every day. And yes, there are some women who have beat their partners. There are. But almost all of them are the men beating the women. You see, I play the entire docket. I don't cherry pick anymore. I show you guys the whole thing. And you see it. You see case after case of men getting mad and hitting her. Yeah, we see some women hitting other women. We absolutely do, but it's... Why, though? Why do we go through dockets every day of this? Of this? I mean, it's every courtroom in every state, constantly, every day. Sex crimes or domestic violence crimes, every single day. Just, I don't know, something, like, what do you do with this guy who thinks he's done nothing wrong? You can, if you force therapy and force meds, does that fix it?
You're the judge. I think it's, his mom's already 74, so we take care of him, she takes care of him. Because his schizophrenia, that's, I don't know, it's...
Bobby, let me tell you something. I was at work yesterday. And there is, so, like, they turn all the lights down when the show goes on. And I roll this cart out to get all the coffee station tore down. And it's pitch black at the back where I'm at. I'm pushing this cart in the pitch black in the back of a full, chock full room of people and people on the stage. And one of my male coworkers, but I didn't know it was my coworker at the time, was following me very closely. I can't see anything because it's pitch black, but I know that there is someone following me real closely. I got for no reason terrified. I was just for a moment crazy scared. So I start pushing the cart faster. Well, when I started pushing my cart faster, he started to go faster. I think that's because he walks normally faster, and I was probably slowing him down at first because I was pushing the cart. Well, when he sped up, I got real scared. I thought, I'm about to die in the back of the theater with all these people here. It just hit my mind because it was very dark, and I was female, and it was very dark. I bumped into the corner in the back of the show. People heard it. I don't care. Trying to go as fast as I could to get away from whoever was behind me, because it's normal for a female in the dark to be scared. That's just normal. Like, if you go out into the dark where there's other people, you should be scared. You should be scared because you don't know. And you don't know because look at these dockets. Every single day, all day long, it's violence and violence and violence and violence and violence. I mean, of course, I was fine. I mean, it was a short 2-3 seconds of me just feeling scared because there was somebody behind me in the dark. that's normal. That's just how we live. You can't be in the dark alone because you don't know what's going to happen. It's just how women live. All women, every single woman. If you, Bobby, you, as a man, were pushing that cart in the dark and a woman followed you closely, how scared would you be? How terrified would you be in that moment? Even though you're at work, you're in a room full of people, would fear even come into your mind that you're going to get attacked from behind? I mean, you can probably go outside at 3 a.m. and walk down the street and not fear a woman is going to harm you. Nobody at my job has ever threatened me. Ever. There's no reason for me to feel scared at my job. But that is just a normal way women live. If it's dark and someone comes close to you. But I mean, are you telling me you would feel scared if you were pushing a cart at a show and someone walked close to you, you would feel scared? I'm calling bullshit. I know you wouldn't. You wouldn't even think that you would be harmed. It wouldn't even cross your mind. It's just normal for us. It sucks.
It's a mental thing that never goes away. But we have them on these pills and stuff. But they're kind of stubborn, so if you tell them to take them, they will not take them. You got to give them his drinks or his food. So schizophrenia works in a different, you're totally on a different world.
He won't take his meds.
Schizophrenia is, it's a sickness. It took me years to understand it before I can understand. I used to call the cops on him every week because I didn't understand how that schizophrenia works. So it took me years and years to understand it. So if I tell him to clean the refrigerator, he'll throw all the food on the trash. I come back from work and all the food is in the trash. So they don't really understand in their mind when you tell them to do something. The schizophrenia works in a really, they're in a totally different world. It's really hard to explain all that. But if you could help us out, I think Carlos would be doing good.
Thank you, Mr. Rodriguez.
Thank you.
Thanks, sir. Mr. Cervantes, anything you'd like to let me know, sir?
Just thanks for the offer, and I won't do this again.
Okay, thanks, sir.
I won't do this again.
Thank you, folks. I've considered the arguments of both parties, the statements of Mr. Cervantes and Mr. Rodriguez, reviewed the PSI and the affidavit in this matter. Obviously, the conduct here, I'm sure, was frightening, potentially traumatic to the minor children involved, and I do understand where the parents of the victims are coming from. Just looking at the harm that was caused here, and not some of the other context, particularly Mr. Cervantes' mental health, I think it's a fair request of more severe punishment or sanctions here. But noting Mr. Cervantes' underlying mental health conditions, schizophrenia, Mr. Rodriguez discussed, does seem to have played into the offense here. Mr. Cervantes does have some criminal history, but it is fairly limited. The underlying juvenile matter was not, the sexual basis there was waived, so that is somewhat mitigated, notwithstanding the allegations there. So I do find probation is appropriate. I think just given the nature of the treatment that's required, and I think it might take Mr. Cervantes a bit longer than normal, I do think a longer term of probation is appropriate. So I'm going to impose 3 years of probation. This will be a non-SOISP supervision. Mr. Cervantes has 2 days of pre-sentence confinement credit, so I'll impose 2 days in the Adams County Jail and grant 2 days of pre-sentence confinement credit. Mr. Cervantes shall register pursuant to statute. Going to the conditions that are at dispute here, the form provided, understanding that it is a form, it is a number of additional conditions that may apply to a case. This form applies to both SOISP and non-SOISP offenses. I do find good cause to impose conditions 2 through 22 as listed on the form. Term number 1 will not apply given that this is not SOISP. Looking at some of the specific conditions and understanding Ms. Cantrell's record, I agree that the court does need to fashion appropriate conditions tailored to the offense and the needs of the defendant, but I don't find good cause to go through and strike line by line portions that are objectionable. And I don't want to be in a position where I'm setting up a power struggle between Mr. Cervantes and probation. But I do find that all of these conditions are appropriate given the circumstances here. Supervision and treatment of those who have sexually offended do have some distinct factors that don't necessarily apply in all cases. And the recommendations specifically here in the offense-specific evaluation include addressing issues of healthy versus unhealthy intimacy, cognitive distortions, establishing healthy boundaries, and a number of these conditions, while they are intrusive, do go to that. So term number 8, as to identifying any sexual romantic relationships and not dating anyone under the age of 18. Obviously, that second portion applies to the facts here, given that there are minor victims here, and informing of romantic relationships ensures that folks are not engaging in secretive relationships, that they are complying with the restrictions of contact with minors, and otherwise exhibiting healthy intimacy and avoiding
Now I'm watching
dishonesty or cognitive distortions. As to number 13, I understand Ms. Cantrell's point as to whether the probation officer is the sole arbiter of completion of treatment. At this time, however, that is not an issue before the court. Obviously, I will issue orders that Mr. Cervantes comply with and complete SOMB approved treatment. Ultimately, I'll make the determination if there is a revocation, whether Mr. Cervantes complied with this. So I don't find good cause to modify term number 13. I'll look at term number 19 and 23 in conjunction. I agree with Ms. Cantrell that term number 23, I think, is overbroad given the circumstances of the case and the information in the PSI and evaluation. I don't find good cause to prohibit any access to the internet.
Okay, he got the internet. He got to keep the internet. He's on probation for 3 years. Hopefully, probation ensures medication. Hopefully.
Term number 19 appropriately encompasses appropriate use of the internet. I don't have the full terms and conditions of the computer use agreement for sex offenders before me, but I'm not going to order special terms 23, 24, or 25. But that being said, I do find that allowing unfettered access to sites that deal in sexually oriented material or sexually explicit material would substantially impact Mr. Cervantes' ability to be rehabilitated, to participate and comply with SOMB treatment. So I do find that additional terms 26 through 29 are appropriate here. Term number 28 is to avoid any behavior associated with inappropriate boundaries, which is at issue here. Term 29 does not prohibit all access to commercial social networking websites, only requires that it be approved in advance and in writing with consultation with the community supervision team, given that minors often are on social networking.
I think they can test him to see if the medication is in his system. Because, Blanco, she has cases that are out, they're not in custody. I mean, we see a lot of Blanco's cases in custody because they're mental health cases. But she has a lot that are out of custody. And she's able to, be like, you're 40% compliant with meds, 80% compliant with meds. I think they test them to see if the meds are in their system.
Sites, and this may allow inappropriate access to minors and forming unhealthy relationships with minors. I do find that term number 29 is appropriate given the facts of this case. So I will impose conditions 26 through 29 in addition to 2 through 22. And 19 requires Mr. Cervantes simply comply with the computer use agreement. I will also order a special exception just to, if this is prohibited by the computer use agreement, I will allow that Mr. Cervantes may access the internet for purposes of accessing rideshare applications as well as for purpose of applying to employment or working at an employer. So obviously, I don't want to prohibit Mr. Cervantes from engaging in appropriate pro-social activities, certainly getting to appointments. I think that strikes the right balance, and then otherwise he'll have to work with the community supervision team for other exceptions. If there are further issues down the road, I'll consider any motions to modify. Let's see. Also order that Mr. Cervantes complete a formal cognitive evaluation as requested or recommended by the offense-specific evaluation and participate with an SOMB approved provider that works with IDD clients if that's appropriate after the evaluation. So we just want to make sure that Mr. Cervantes is getting the right type of treatment with the right provider there. I will find pursuant to Burns that given the facts of this case, given that there was exposure to minor children and concerns about impulse control and reoffending behavior, Mr. Cervantes shall not have contact with any minors unless that's approved by the community supervision team. That will include any minor nieces and nephews. I do find that there's a compelling state interest in ensuring Mr. Cervantes' rehabilitation as well as to ensure safety of any other minor children. And there's no less restrictive means to ensure those goals are met. Finally, I'll also impose or require Mr. Cervantes complete a substance abuse evaluation, treatment, and monitored sobriety at probation's discretion, given some of the concerns raised in the evaluation. So just to be clear, that portion will be at probation discretion once Mr. Cervantes is working with probation. Ms. Kent, and I'm sorry, no restitutions being requested, so sentence and judgment will be final. Ms. Kentrell, anything I missed or any further findings you're asking for?
Yes, Judge, are you ordering that he must sign the computer use agreement for sex offenders?
Yes.
And then I just asked the court to clarify how condition 19 relates to his rehabilitation.
Thank you. I did touch on that, but just to specify it to 19. So again, unfettered access to the internet provides unfettered access to sexually explicit or sexually oriented material. I find generally, given the SOMB terms for sex offenders as well as specific to this case, that access or unfettered access to that type of material would prohibit Mr. Cervantes' rehabilitation and participation in SOMB treatment.
And is the court finding that condition 5 from the standard terms and conditions of probation would not appropriately achieve that goal?
Yes.
Okay. My last question is about condition 28. That condition would bar Mr. Cervantes from having any cell phone at all, or anything other than a flip phone, because it bars any cell phone with a camera or recording device. And so I would ask that the court reconsider that condition and then just leave 26, 27, and 29, given that the court gave exceptions for employment and Uber/Lyft.
Okay.
I understand the spirit behind what the condition is, but I think the effect ends up being that essentially you can't have any cell phone that has, because there's no cell phones other really than flip phones even that don't have any kind of recording capability.
Okay. Thank you. I will reconsider the court's orders as to term 28, given that it would effectively prohibit any cell phones, given that there's no indication of inappropriate recording or observation of others without consent. I will not impose term 28 at this time. Again, to the extent that that type of behavior is covered under the computer use agreement, Mr. Cervantes shall comply with that.
I don't have any other clarifications, Your Honor.
Okay. Thank you, Ms. Cantrell. Ms. Lansbaum, anything further?
No, thank you.
Okay. So folks, we'll have some paperwork for Mr. Cervantes to sign, and then check in with probation on the third floor before you
Yeah,
leave.
we'll take him, wherever we gotta take him so he completes all these,
Okay, perfect.
But thank you, we're sorry, and, yeah, thank you.
Well, that's right. I appreciate you being here, Mr. Rodriguez, and thank you, Mr. Cervantes. Thank you, folks.
Your Honor, just the FTAs.
That's what I have. We'll start with Mr. De Leon. This is 24.
Sir, you had your time with me. Don't be greedy. We have to go now. We're done. Tomorrow is Thursday. Tomorrow, we're going to do the divorce case with Judge Crawford. And if you wanted to see a 10-minute preview of what you're going to see tomorrow, there's a link. It's going to be good. Tomorrow's going to be good, good, good. All right. Thank you so much for coming out today, guys. I really appreciate it. Bobby, I'm going to try to find women who beat up men for next week for you. Then we'll have a whole bunch of women cases for you. You'll like that. All right, guys. I hope you guys have a great day. I will see you all in OJ in a few minutes. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself.